Good evening, everybody, and thank you, Lisa. I'm Linda. And Lisa, I just want to confirm, have you made us co-hosts for sharing? Oh, I see. Never mind. Marina was ahead of me here. So thank you, everybody, for making time to join us this evening, and thank you very much to Lisa for organizing this because I know you have lots of plates in the air, full plates that are spinning, and so thank you so much for doing this and for inviting us to speak. Um, so as Lisa mentioned, I work on the public education and outreach part of Seniors First BC. So I'm going to do like the beginning part, an overview, and then I'll of what Seniors First BC is about and the services that we provide. And then I'll turn it over to Marie Noel, who is not only our executive director, but a lawyer, and she can speak to some of the legal pieces that the tools that people can use for advanced planning, like wills and powers of attorney and so on. So yeah, thank you, Marina. I will mention that this information is only for information and not to be considered as legal advice. And if you are looking for legal advice, one option is to contact us. That's one of the services we offer is legal services. So we have contact information there, and I'll also be talking about that in a couple of minutes. Okay. All right. So as I mentioned, our learning outline. So I'll do the introduction to who we are and what we do, and then we're going to go through in a little more detail about advanced planning tools, finishing up with some resources, and then obviously time for questions. So start with who Seniors First BC is all about. So as Lisa mentioned, we're a nonprofit organization. We've been around for, we're in our 31st year now. And we provide information, legal advocacy, and support across BC, not only for older adults specifically, but also with people who are involved with an older adult. So all of you folks. And we have four main program areas that I'll talk about briefly in the coming slides. So we have our Seniors Abuse and Information Line. You'll hear me say SAIL quite often throughout the presentation, and that's what we're referring to. We also have victim services support, the public education and outreach, and then our legal programs. So the most important piece to remember initially here is about the Seniors Abuse and Information Line, as I mentioned, called SAIL. And this is a confidential phone line managed by trained workers, and it provides a safe place for older adults or people who are involved with an older adult to speak with one of our trained staff about situations of abuse or mistreatment or other concerns about an older adult's well-being. This phone line, the Seniors Abuse and Information Line, is also the way that you would get access to our other programs, such as the legal services. Our staff would do an intake over the phone, so there's no paperwork. Our staff can also provide information and refer people to other resources in the community based on what the needs are of the older adult. So I'm not sure where everybody is coming from tonight. I'm speaking to you from Vancouver, so on the unceded territories of the Musqueam, Squamish, and Tsleil-Waututh Nations. But we have two contact numbers here, our Lower Mainland number, and then toll-free from anywhere in the province. And this phone line is available from 8 a.m. to 8 p.m. Monday through Friday, except for holidays. And we do offer language interpretation. So when somebody calls and they're connected to the staff, they just need to say the language they'd like to speak in. We can also arrange for American Sign Language interpretation too. Another way to reach us if by phone isn't a useful way to access us, you can also send an email to that address there. So one of the programs that our phone staff might refer someone to is our program of victim services. And this is for older adults who have experienced abuse or family or sexual violence. Again, it's province-wide service, and it's telephone-based support. People don't need a police report to receive service. Again, you just go through that telephone line, and the intake will be done with the sales staff. And so then what our worker can do is help with ongoing safety planning. So helping people get, comfortable and learning about what might happen in this case or this case, helping them navigate the criminal justice system. And then similar to our phone line staff, our victim service worker can also help people connect to community resources. So someone might need longer term counseling or housing assistance or financial assistance. And then there's my part, so the public education and outreach. And so what we're trying to do is not only bring awareness about the programs and services that we offer, but awareness about key issues that affect older adults. So we do this through presentations such as this one and attending various community events, generally more in the Lower Mainland. But some of the topics we might address are things like elder abuse or frauds or scams, government benefits, and then of course what we're going to speak tonight about advanced planning. We also are involved in producing various publications, and we have a newsletter that comes out mostly every month. And so I would encourage you to, feel free to sign up and subscribe to our newsletter for more information about what's happening, issues that impact seniors, events that are coming up, and so on. And then there's our website there. Since you're on Zoom, I guess everybody has access to a computer or the internet. So I encourage you to check out our website for more information about our programs and services, as well as links to a number of resources that are relevant for older adults. And then one of the ones I wanted to really highlight for you is a guide that came out last year that we were involved in researching and producing. So this is about navigating home care and senior housing. And in there, and Lisa, I know you're familiar with this. And so it's quite an extensive and comprehensive document. It's a Click Law wiki book. It's accessible only online, but there is a link, as you'll see on the screen, on our website that will take you to that. And then you can download information if you like. It's a PDF document. But it's relevant for you. It includes information about entering and leaving assisted living or entering and leaving long-term care, issues that might come up while someone is living in long-term care, such as the care plans or medication, the rights of residents, resolving problems. And then it also talks about the laws that govern residential care services so that people have an idea about what they can expect and then be able to advocate for themselves. So that's, again, accessible through our link on our website. And then our final program is in high demand, is our legal services. And here we're trying to reach lower income older adults who are eligible. We have certain criteria that's there, and I'll go over that. And we can assist people with certain legal issues, not everything. But one of the areas that we really do a lot of work with is advanced planning tools. And our services can range from providing just general legal information and maybe referring to other resources, offering summary advice over the phone, drafting legal documents, and that, among others, includes wills, powers of attorney, and representation agreements. And in some situations, we may be able to provide full representation in court. So the big question is always about the criteria for eligibility. So we go by age. So it's 55 and up. And then if somebody identifies as Indigenous, 45 for them. And then the maximum income for one person is $45,000 per year. That's before tax, and $20,000 for any additional household member. And then we also consider total assets, so under $250,000 in this case. We can consider exceptions on a case-by-case basis. Obviously, some people might be facing multiple barriers, and so we will consider a person's situation. The question about whether we provide visits or virtual support to clients where they live, in this case, perhaps in a care facility, or do they need to come to our office or one of our clinics? Marie Noel, can I throw that one over to you?
Sure, and good evening, everyone. Before I start, I just want to acknowledge that I'm joining from the traditional, ancestral, and unceded territory of the Katzie Nation. But Seniors First BC operates throughout BC, and that means that it spans the territory of over 200 First Nations. So going back to that question, we occasionally have legal clinics at long-term care facilities, even palliative care. At some point, we had ongoing one at May's Place. Whenever possible, we prefer to have it at one of either at our office or one of our partners. So the best thing to do is to call sale and see what is needed. We don't do home visits. So we may be able to go to a long-term care facility or an assisted living facility. I mean, you would not be interested in that, but for the long-term care facilities, um, but yeah, it depends on how far it is from us or one of our offices. Sometimes we do it virtually. So if someone is able to facilitate a Zoom call, we may be able to do that, including advanced planning. However, if what you need is a power of attorney or a will, we would need someone who's unrelated to the client to do that because we cannot have an interested party in the room when we take instructions about a will or a power of attorney, if that makes sense. And that's because I mean, part of our ethical duties is ensuring that the person uh, is not pressured to make certain financial decisions or have certain clauses in their will that will benefit someone. And it can be to protect their interest as well. So even if you are the primary caregiver and you love your, spouse, child, sibling, close friend, it's also to protect your interest because if anyone disputes that the document, the instrument, the will, the power of attorney was made out of their free will, then the lawyer's notes can be requested. And in those notes, it would be helpful to state that there was no interested party in the room. So it's more on a case-by-case basis, but it has happened and happens regularly.
If I could just jump in as well here too, if someone's able to go to our office, we have an office located in downtown Vancouver. We also have monthly clinics around the Lower Mainland. For example, Burnaby, New Westminster, Surrey. Where am I missing? And then outside the Lower Mainland, we have clinics offering advanced planning assistance. All of that information you can find on our website as well. It gives you a map of where things are. And in any case, all of those inquiries would need to go again through the Seniors Abuse and Information line because we need to do an intake. We need to actually book an appointment. We don't have just walk-in appointments.
On this, I know where are people joining from today? I don't know if it can be put in the chat, so it would give me an idea of. Oh yeah, I see that question. Affiliate locations elsewhere in BC. Yeah. So, but yeah, if you can put in the chat where you're joining from, I could mention any clinic nearby. But we have some in Chilliwack, Nanaimo, Victoria, in the north. So we're planning on doing a kind of a tour this summer. Actually, we go a few times a year to Prince George, Prince Rupert, Haida even. So where else do we see? Mission, one mission is to the Boulder Tri-Cities. Okay, I live in Picpus myself, right? So, and I've done visits in Puerto Coquitlam. So Wasen. Okay. So yeah, and we are looking also at expanding our clinics on an ongoing basis. So sometimes we have social workers who contact us and they facilitate a Zoom call or a clinic, and then we have to look for witnesses whenever required. West Kelowna. Okay, so there's a clinic in Kelowna. I was there in December just before the holidays, and I plan on returning there at the end of the month, so maybe in February. Okay. Thank you. Well, I guess that's getting into my part. So now I'm going to talk about advanced planning tools. So there's a lot of information. And so there's a lot of confusion too, generally about all of those documents. I will try to demystify some of them, going about which ones are valid when, and I'll be happy to take questions at the end if possible, unless there's some confusion, maybe you can put in the chat. And Linda, if I'm not checking it, if you can just stop me and say there's a important question coming up. Okay, so first of all, I'm going to talk about representation agreements. So there are several types, but generally, Representation agreement is a written legal document signed by you or the adult. That's under the legislation. The adult is the person who appoints one or more people, the representatives, to make healthcare or personal care or sometimes financial decisions on their behalf. So the adult must sign in front of witnesses. So one witness, if that witness is a lawyer or notary, or two non-lawyer, non-related witnesses if there's no lawyer or notary. But the representative does not need to sign in front of any witness. And that document can be revoked as long as the adult is capable. The most common one and the broadest one is a Section 9 representation agreement. And that does not deal with finances. It's solely focused on healthcare and personal care decisions. So that can include day-to-day decisions, minor healthcare, major healthcare decisions as well, not made. Only the adults can decide for themselves about MAID. That's a question that comes up sometimes, or when I meet with clients, they ask, can I put in instructions there about MAID? And no, it's only something you can do while you're still capable. There can be additional powers, express powers given in that document about their beliefs, what should happen if they're near the end, who should be coming close to them, to their bedside, if they want or do not want certain medical procedures, such as transfusions or things related to their diet or physical exercise, or who they want to see or not see, right? Visitation rights. The representative can refuse certain medical treatments, and it's often combined with a power of attorney. So the gold standard, really, in terms of advanced planning or incapacity planning, is to have a representation agreement, Section 9, and a power of attorney. So the representation agreement, Section 9, would deal with healthcare and personal care, including admission to a long-term care facility. And a power of attorney would appoint someone to make financial and legal decisions. And I'll go in more detail about power of attorneys a bit later. So Section 7 representation agreement combines financial and healthcare. It can. So it can be limited to just finances, or it can be just for healthcare, but it will not be as broad as a Section 9 representation agreement. So usually a Section 7 representation agreement is used when someone has diminished capacity and they don't meet the legal tests for capacity to make a Section 9 representation agreement or a power of attorney. So they may have early signs of dementia or some other cognitive decline or some other disability. And so it's the last step before it's too late to make any type of documents. It's not always accepted for moving into long-term care facilities, although the legislation is a bit out there. So the Representation Agreement Act will state that this only can be used for certain care facilities such as group home, but it doesn't mention long-term care facilities. So that's in the, sorry, you're nodding, like there's three. Lisa, what do you want to say? Because I see you're saying no. Are you disagreeing or?
No, I'm saying yes, we've heard this complaint, people saying that we have a representation agreement. I don't understand. So go ahead.
Okay, for sure. Yeah, so it is actually in the legislation, but it can be very confusing because the Healthcare Admission Act talks about substitute decision makers, and that includes a representative. So long story short, if you run into that, I would really urge you to try to get a legal consultation if you qualify. We may discuss that and see what's happening there and how we may be able to assist. Yeah, so when it's really too late, if someone doesn't have a power of attorney or a representation agreement, there are a few ways. Either they can see if they can be appointed as substitute decision maker, or they, in the worst case situation, either the public guardian trustee can assist, or if whoever wants to be the guardian of the person has the means to do so, they can make an application in court to become a committee. Like it's a committee of the person, committee of the estates when it comes to finances. But that's costly because you need 2 medical opinions. And currently what we've seen, because we help occasionally, because it's expensive, clients who want to make those applications to assist a loved one because they have to use their own funds to pay for rent or for services. And it's about $5,000 just to get the 2 medical opinions, $2,500 currently per medical expert opinion, and you need to, so it's $5,000 before even legal fees are considered. So it's good to have a power of attorney or representation agreement. Everybody should have one, in my opinion. So when you choose a representative, obviously you should choose someone you trust, who understands and respects your values, wishes, and beliefs when it comes to, finances, spiritual beliefs. And it's really important to have those conversations. And if you are appointed as representative, it's good to have those discussions about, what should we do if X, Y, and Z should happen? When if you have surgery, if you're unconscious, when it comes to end of life care. Don't delay having those discussions. I mean, I'm talking to the choir here. A representative can also assist in making personal care and healthcare decisions before someone is incapable. So it's something we discussed more during COVID, during the pandemic when there were issues with visitors, visitation rights, who can come, who cannot come. So if you are a representative, you should be allowed to come in and visit someone in hospital or in the long-term care facility because you are the designated person who can help the adults in making some decisions because maybe they are still capable, but they don't understand everything that's going on, maybe due to medications or their own diagnosis, and they need someone to help them understand what's happening to them and making those decisions, whether it's about their healthcare or personal care, what they should leave, and what should happen next. The representative can also decide who can be a visitor. So it's a huge responsibility, and again, that's why it's important to have those discussions because sometimes I talk to clients and they have children who don't get along with each other. And so, I get into that. Would it be possible that if you appoint so-and-so that they would deny visitation rights to the other child or their children or people who you care about, but they may not like. So it's really important to have those discussions with them. And to talk about, your and their medical treatments and medications, so they're aware of what the adult is taking and can have those discussions with the doctor quickly.
Marie,
So,
sorry.
Yep, sorry.
Pardon me. There is a question in the chat around the Section 9 representation agreement, more or less whether a question about whether the health authority or long-term care facility can bypass or sideline that representative by asserting that the adult is capable. I don't know if we want to leave that for the end or if we want to address that
That's
now.
fine. Again, so it is a good question. So when you make a Section 9 representation agreement, the representative is there to assist you in making decisions as long as you're capable. But the capable adult has the final say, and the medical provider has a duty to check whether or not the adult is capable of making the decisions. If the physician or healthcare team finds that the adult is still capable of making those decisions, then they must listen to the adult themselves and not the representative. It's only once the person becomes completely incapable that the representative decides. The second exception would be if an adult is incapable or is capable but has been detained under the Mental Health Act. And the Mental Health Act trumps the Representation Agreement Act. In other words, if someone is a representative of another adult who is on a psychiatric ward, then that representative does not have any say about the psychiatric treatment. Okay.
One sort of further question is about whether because capacity, or the question is around whether capacity can be fluctuating. Is it an all or nothing, all or none situation?
Yes, capacity does fluctuate. As we well know, you can have someone who's fully lucid in the morning and they get medications and they're no longer able to make those decisions. Or, during surgery, you get surgery, you get anesthetics, you don't know what's going on. So then the representative should make those decisions on the adult's behalf. But once they fully recover, then the adult should be able to make their own decisions on their own behalf. So it should be assessed regularly, unless the person is deemed to be, permanently incapable of making those decisions. Okay, so for advance directive, well, I think I'm going to answer the question as I go. An advance directive is usually, not always, but ideally used only when you don't have a representation agreement, because you cannot put all the various case scenarios in a representation agreement. So it's good to have someone you trust who can be your representative, your advocate when it comes to healthcare and personal care decisions. But when you don't have anyone, then it's better than nothing to have an advance directive listing what you would like for yourself. Like, who would you like to see if you become sick or incapable? Maybe you still want to see friends, but those friends or family members are not able to become representatives, but you still want them to be notified if something happens to you. Or what type of treatments you want or don't want. Some people don't want, CPR or blood transfusions, or who knows, right? They may have spiritual wishes as well. Now I'm going to get into powers of attorney. So a power of attorney is a written legal document signed again by the adult, and in this context is the person who's granting the power of attorney, who's appointing someone else to be their attorney. And the term attorney is misleading. It doesn't have to be lawyers. Whoever is appointed under a power of attorney to make financial and legal decisions on their behalf. Something that is really important, because people get confused with this all the time, is that the power of attorney is only valid when the adult is alive. So I hear all the time people telling me, I have everything in place, I have a power of attorney. Well, this power of attorney has no effect the minute you die. So they can't access or shouldn't access your bank accounts. They can't do anything with respect to your car once you're dead. It's just not the case. So power of attorney is only valid when the adult is alive. In this instance, the adult and the attorney or attorneys must sign in front of witnesses. If there's any real estate involved, there must be a lawyer or notary involved as a witness. If not, then there can be two non-lawyer witnesses or one lawyer or notary. And it can be revoked as long as the adult is capable. However, if what just happened? Sorry. If it's revoked, it is really important to notify the financial institutions who may have accepted that power of attorney, so they know to stop accepting any transactions that are made by the attorney. So it's used for financial decisions, business decisions, banking, property, and that can be real property, that can be vehicles, and legal decisions. It has no effect with respect to healthcare or personal care matters. And it can be as extensive in terms of powers or as limited as what you want. It could be just, I give you the authority to sell my car, and that's it. So there are two main types, or there are more types, but the two main types of powers of attorney. You can have a spring power of attorney, which is less common. So it means that it is dormant. You sign it, your attorney sign it, but it is dormant until the specific event that is mentioned in the document happens. So the most common type of spring power of attorney would be one that is effective once the adult is assessed as being incapable. So I appoint my I don't know, my good friend, but I don't want them to touch my finances until I'm absolutely incapable. There are pros and cons with that. One issue can be, especially in rural communities, finding a doctor who's going to be willing to issue a certificate of incapability. So that's a huge barrier. Also, there are people who may have physical issues, but they are completely capable. And so if you have that clause in your power of attorney and you just don't want to go in person to, the post office to send registered mail and sign documents to for sale or to write to the landlord, you don't want to do certain transactions in person, that attorney will not be able to help you because you had that clause that said that it's only effective if you are incapable. So the most common and the most immediately useful type of power of attorney is an enduring power of attorney. Is a general enduring power of attorney that is effective immediately as soon as you sign and the attorney or attorneys, if they are joint attorneys, sign. And then it continues to be effective even if you become incapable. And in that case, they could still help you with financial transactions, even if you're capable, but you just don't want to go in person or it's just complicated and you don't want to deal with it. When you have an enduring power of attorney, both you and the person you appoint, so both the adult and the attorney, have the ability to make those transactions or to take care of those legal affairs. So remember, for the representation agreement, the healthcare team has a duty to check with the adult to see if they're still capable of making decisions. But and then if they are still capable, then the adult should make those decisions. It's not the case for an enduring power of attorney, for an enduring one. That means that you can go to the bank and withdraw money or, hire a lawyer or sign a lease. But if your attorney does that, they can do the same. They have the same powers as you, unless there are some limitations in the document themselves. So I don't want to go too much in the nitty-gritty details, but I hope the big picture makes sense. I'm just going to pause here for a second to make sure that that's clear. Yeah.
So there's one question that I think might be answered once you talk about the joint bank account thing, but the question is it better to have a close family member be a co-owner of the bank account so it stays in force after death?
Yeah, I'll go into that.
Yeah. The other question,
other?
I'm not sure if you've answered for the person or not, asking about a POA, whether it's full and indefinite. I think maybe with the springing and enduring, that's been answered. If it's not, if that person could maybe ask the question again, if that hasn't been answered.
Yeah, I'd appreciate some clarification on what that question means. I can check the chat. Who did ask? Someone.
Sahila, did we answer the question?
Yes. Good evening, everybody. My question is, if the person is capable and then make this power attorney, for example, with children, and give them the full power attorney, you mentioned that if the person passed away, then the power attorney is resolved after that. But if it's full and indefinite, then can the attorney just just sort whatever is necessary after the death of the parents, for example? No.
The minute the adult passes, the document stops being effective.
Even so even if it's signed in with the lawyers and then it's a legal document, it still is not valid after the death.
Never.
Okay, thank you very much.
Yeah, you're welcome. And it's a good question, and I'm glad you asked it because people get really confused. So I'm a lawyer, I do this all the time, and people get confused by that all the time. But it's under the, I'm just sharing my screen, not my, just that window. But at the end of this time, I'll go to the Power of Attorney Act and I'll show you the legislation. So when it stops to be effective, and that includes death.
Okay, thank you very much.
Yeah.
That's all the questions so far.
Okay.
We'll get to the bank account question when we talk about that.
Yeah, so I touched upon that briefly. If it's general, so basically whatever the adult can do, the attorney and the power of attorney can do. If it's specific power, like I said, if it's just for a car or a transaction, then it's all they can do, right? So sometimes the most common type of specific power type of power of attorney would be a bank power of attorney, because it's limited to the account, to one account or more accounts that are held in a specific financial institution. So if you have a power of attorney at the bank, then it would be only valid for that bank. So for example, if someone moves to a long-term care facility, it might work in terms of setting up payments, but you can't sign the document that the long-term care facility gives you as attorney. Maybe a substitute decision maker, you may be able to do so, but not using your power of attorney, because the power of attorney does not allow you to do anything else other than giving instructions to that bank about the funds held by that institution or the bank power of attorney. So any other legal action, financial affairs, like dealing with landlords, dealing with property management, vehicle, that would not work. It's really just what's in the bank. And there's a word of caution here, in that new powers of attorney can revoke existing powers of attorney. So if you have one at the bank, after having made a general power of attorney at the lawyer's office, that would be for anything you have, then technically the bank power of attorney could revoke the first one, because typically at the start of every power of attorney, there's a clause that states, I revoke all my prior powers of attorney. So now it may not revoke it effectively, because it depends on who's notified of the new power of attorney. But if it comes to the attention of an institution or a lawyer or a long-term care facility, they're presented with two powers of attorney, where it's possible that only the last one would be effective, and it would nullify the first one. So whenever you choose an attorney and a power of attorney, you should choose someone you trust. They have immense powers, especially for the general enduring powers of attorney. It's important that they understand their duties. I always tell attorneys that they should have an Excel spreadsheet or a notebook, as simple as a notebook, where they put the date of each transaction, how much was withdrawn or transferred, and for what purpose. Because if there's any allegation of financial abuse, or if there's an investigation by the public guardian trustee, they will ask, what was that transaction for, and see if you were diligently acting as an attorney and doing your job and not benefiting yourself. So there are lots of disputes. It's not like it happens all the time. It's just a good practice. And it's also good to think about trusted alternatives, because the attorney can also, become incapacitated themselves. They can be in a car accident. They can leave the country. Maybe it's just too much work. So always consider alternatives. Like, who would be a good alternate power of attorney or an alternate representative? So now I'm going to get into joint ownership, and just after I'll talk about joint bank accounts. So joint ownership is what most people know about. Something is in two names or more names. And generally, once it's jointly owned, it's shared property. So all the debts are in commons, and they're all responsible for that account. So there are some good things about joint bank accounts and bad things. So, okay, so if you truly trust a person, the most common scenario would be with a spouse or partner. So two people own 100%. It's not like 50-50, which means that There's also right of survivorship. So if one of the bank account holders dies, then the other one becomes the sole owner of that bank account. And that could be great in some case scenarios, again, like spouses that they fully trust, and what they want is that, you know, when they die, their spouse gets everything. There might be issues when it comes to other types of relationships, or if there are conflicts within that relationship. But for example, let's say you have no spouse, but you have two kids, and you decide to put your local kid who's close to you as your as the joint owner on your joint account. So you make your account joint, and you have, let's call them Joe is going to be the joint bank account holder, and you have another kid who's Joanna. So what it means is that they own that account. If they have debts, these debts could become your debts. So that's something to really think about when you choose someone to be a joint bank account holder. The other thing is, and that really depends on the financial institution, so it's good to have those conversations with your financial institution or your loved one's financial institution. There needs to be in conversation, because some financial institutions specify what should happen upon death. So it could be that when I die, the right of survivorship applies, meaning that the joint owner will get everything on that account. Or it could be that there's a presumption of resulting trust, meaning that when I die, the other account holder doesn't get everything, and if it goes through my will or follow the law upon intestacy, there's no will. So if you have, if you decide that Joe will not get everything, it would mean that under most common circumstances, Joe will get 50% of what's on that bank account, and Joanna will get 50% of what's on that bank account. But again, it depends on the financial institution and how it's set up. So it could be that you just wanted Joe to help you with your finances, you put them joint on the account, but you didn't really think about the fact that you might disinherit Joanna as a result. Because you died, then Joe gets 100% of the account, and then you may have a will that says that everything is split in half. But if your main asset is what's in your bank account, what will happen in some, not always, but what could happen is that Joe gets everything, and you have a valid will, but there's nothing left to distribute because you have a joint bank account and Joe will get 100%. So again, there might be a work around that. That's why it's good to talk about those issues with your financial institution or the financial institution of the person you care for, and make sure that the joint bank account holders understand how things are set up, because there are the risk about debts, and there are the risk about what happens when someone dies, who gets the money. Yeah, so just think about that. Did I answer that question?
Does that address your question, Lisa? Or anybody else who was wondering? There's one more question here, and Marie-Noelle, it's kind of going back to the POA question about the fact when somebody passes, that the power of attorney stops. But if you're the executor, you would continue to manage the person's accounts. Is that correct? So that's
yes, if you are the executor and you're the attorney. So one person can be everything. A person can be a representative, they can be the attorney, they can be the executor, they can be the sole beneficiary, they can be everything. It really depends on how it's set up. It doesn't have to be that way, but it could be that way. So it's part of the interview process. When a lawyer like myself meets with someone, we talk about who's in your close circle. And maybe that one person is the only person you have, and that's great. Or maybe you have an abundance of choices, and you have a nurse in your family who would be a great representative under a representation agreement, because they understand all of the medical word and jargon and the procedures, but they may not be the best power of attorney, like attorney, because they don't have the time, or you have someone else who's an accountant and who would be much better suited for that role. So really, it's part of the discussion that you should have with a legal professional.
May I just ask a question myself here? So just to clarify, the executor and the power of attorney is two different roles. Power of attorney ends when the person passes. The executor begins when the person passes.
That's right. That's a perfect summary. Thank you,
All
Linda.
right. Yeah.
Okay, so we get into wills. So good transition. So I think everybody knows what wills are. They contain instructions about what you want done with everything you own and your body. So in that document, you should appoint an executor. However, we have clients who don't know who could be executor because they just have beneficiaries, but no one who could do that. And there are ways to appoint corporate executor and trustee, or as a last resort, the public guardian and trustee, and they do that for a small fee, but they have to accept the appointment. And if the public guardian and trustee is appointed, then they keep the will. Just a small aside here. So a will is only effective after death, so power of attorney is before and the will is after. So something like organ donation, in my view, should be in both, because really it would be good for the representative to know what's going to happen, but it's also good to put it in the will so that there are no surprises, and people also know what the adult wanted. So some assets cannot be divided in a will. So that could be a joint bank account, that could be life insurance, or any investment account where you appoint a beneficiary. So life insurance, there's so many other assets that where you just appoint a beneficiary, or you have joint property, and then it just goes to the joint tenant, even if it's real property, it's called a joint tenancy. Then it just trumps the will, goes straight to the beneficiary. And that's why when there's an appointment with a lawyer, it is important to go over all of your assets and debts. So it can get a bit nosy, ask a lot of questions about what are your assets and your debts, thinking about each bank account. I can't remember, after a few appointments, who has what, but we have to ask those questions to each client and take detailed notes so that we can also advise them on what will happen after the pass. And we want the document to be effective. So you don't want to have really long instruction about something that will never go through the will. So for a will, it's good to think about who can be a reliable executor. So someone who has the ability to take on that role, who's not going to panic, who's not going to be too emotional, because it's extremely emotional to deal with a loved one's death, and who's able to deal with a funeral home, the various beneficiaries, if there are some, resolve disputes, maybe be a bit of a mediator, someone who's good with accounting. Think about what should happen if any of your beneficiaries die first. Think about your pets, if you have any, where do they go? And yeah, so for each beneficiary, think about what should happen. Think about also if there are any minors, who should be the trustee of their assets if their guardian dies first. So let's say you give money to your kid or your good friend, and they have kids. You may say, if they die first, then it goes to their child. Well, great, but if they die first, who's going to be the trustee for those funds until the grandchild turns 19, or the child of your friend? So thinking about who should hold those funds and manage them on their behalf. And please gather information so you don't waste time, like whether you pay for a lawyer or you see one of our lawyers, be prepared, have the full legal names, not just, their first name. Make sure the spelling is correct for anyone you name in that document. And that's good for all the documents I just mentioned, whether it's a representation agreement or a power of attorney or will. Make sure you have the full legal names of anyone you name in that document and their full legal addresses, particularly for the executor, the attorney, and the representative. For will, if you're not sure about the legal address of one of the beneficiaries, really what it boils down to is, will the executor be able to locate them? Questions about, is there a will template available to use? So some organizations offer will templates, we can't do it. Really, because we find that we have to tailor our own templates all the time. We have to ask all of those questions about assets to make sure that people don't include disposition and instruction that will not be effective because of joint ownership, because of disability. If you have a loved one who is disabled, maybe you don't want to give them money outright because they will no longer have access to their benefits. They will have so much money that they won't be eligible for benefits anymore. And it might make sense to set up a discretionary trust. I don't want to go too much into the weeds here, but yes, there are will templates. But we don't provide any. I think at some point Nidus had one. You can check, but we can do it. When we talk to our funders, we're not supposed to do it. So how many witnesses are required when signing the will? Two independent witnesses. So no one whose name as a beneficiary. Shouldn't have your spouse, your kid, anyone who's a beneficiary be present when you sign the will. So we have to exclude beneficiaries from the room during the interview and when we execute those documents. There's one exception to the number of witnesses, and that's for First Nations living on reserve whose will it goes under the Indian Act. If the Indian Act applies, if that's a jurisdiction, then the Indian Act says that it just needs to be dated and signed by the will maker. But even then, we still want to have two witnesses to make sure that under any legislation it's valid. Oopsie. Any questions?
There's
on
one
this?
question here, and you may address it in the next slide or two, but what if the executors are also beneficiaries and those people are brother and sister of the adult who passes, but the brother and sister don't get along? So could the person put in their will to have those beneficiaries hire a third-party executor? Could you have those instructions?
Yeah, I would probably, well, I don't know if they, I wouldn't have in the will, okay, we're getting into like lots of detail, but okay, I wouldn't have in the will like, well, they have to find an executor. Like, no, that's your job. So sometimes I see that when I take instructions, well, they can do whatever they want with my body or ashes. We've had litigation over ashes because like some people wanted to have the ashes of their mother, right? So please don't think that it will all go well. So if you really think that the siblings won't get along, find someone else if possible, or consider having the public guardian and trustee be the executor. But just know that anyone whose name in the will has the right to see the document and will get a copy of the will. So maybe they will be able to get along when if you say everything is 50-50, the question is, are they going to actually abide by the instruction in the will? That would necessitate a longer conversation to see like what's going to happen, how is it going to play out? But yeah, I would say choose the executor yourself if you can. But you can have them otherwise as executors or co-executors. But yeah, it needs to be discussed. And I would encourage people to have this discussion with their children as well. What would happen if I name both of you as executors? If that's safe to do so. And the executors are not entitled to a copy before the death of the loved ones, but if you make a will and you trust your executor, you can have them keep the will. It's completely up to you. So when you choose an executor, choose someone you trust who can handle the required duties, as I mentioned, to the funeral home, deal with taxes, probate, satisfying all the debts and distribution of assets, who's good with details and record keeping, especially if there might be some disputes, and can manage disagreements between beneficiaries. Someone who will follow your wishes, even if they disagree with your wishes. So, for example, some people want or don't want a religious ceremony. So will your executor abide by your wishes, whether they agree or not? Like, have those discussions with them if possible. Or if you're going to be an executor, or you like try to have those discussions if possible with your loved one before it's too late. And whenever possible, it's good to pick someone who is conveniently located or who is going to be able to come to you when it's about that time. So if someone dies without a will, what happens? So family members should inherit in the order set by the law. So you have spouse, children. If there's no child, we go to the parents and you look at the siblings. And there's a whole list. And if there's no one on that list who's alive or can be found, then the government of BC can inherit. It's a bit different if it's unreserved, but I'm going to assume, unless someone says in the chat that they are interested in the specifics of what happens for First Nation Reserve, I will not mention it. And then an administrator would become like an executor. So when we talk about executor, it's under a will, and an administrator is the person who has the same duties, but who has been appointed by court to carry out the same tasks. And as a last resort, the public guardian trustee may be appointed. I should add that in some cases, when the estate is really small, so usually under $25,000, there might be a way to have those assets distributed, even if there's no will, but that will depend on the financial institution. So when it comes to the storage of wills, we always tell people to store their will in a secure but accessible location. So if it's in a fireproof safe at your home, who has the key and how are they going to find it? If it's at the bank, how are they going to be able to get to that safety deposit box at the bank? Because sometimes it's like the chicken or the egg. If you need to show that you're the executor to be able to access that safety deposit box, then how are you going to do it? Some financial institutions, again, may have a policy where they might be able to open it and see if there's a will. But again, it's just simpler if there are clear instructions as to where it is and how to find it. Now, there is a form. It's a wills notice form that is filed with vital statistics. And that just indicates, like there's a copy on the slide, where is your last will? What's the date on that will? And where it is stored. If you file this form or help someone file this form, please do not send the original will along with it or a copy. Just send the form. It's only for the purpose of proving that the will that you have found is the right one. So basically, when someone goes to the probate registry, they must show to the registry and the registrar that this is the last will and testament of that person. So if the testator or the will maker has filed a wills notice, it makes the executor's job a lot easier, because they will go to the registry and say, okay, I've done a wills notice search. And it indicates that the last will was made on January 6, 2026. And the will I have here that I have found is made on January 6, 2026. It was executed on that day. And I found it at my home because I was the one who kept it. And on that will's notice, it states that it was kept at my place. Or I found it in mom's affairs, and it stated here that it was at her apartment. So that's the advantages of filing that form. It is not a legal requirement to file that form, but it makes the job of the executor simpler. It just protects the validity of the will, if that makes sense. And there's a note here that I added to please don't remove staples from any document because it can raise questions as to whether the document has been tampered with.
So there's a few kind of related questions here, Marie-Noelle, about the will storage. So I think you've addressed it, but just to bring it up again, do lawyers or notaries have a responsibility to file the wills notice? And is it common practice for a lawyer to register the will with vital statistics?
It is common practice for a lawyer to at least advise their client. So I can say what we do. There's no legal requirement to say so, but that would be odd if a lawyer didn't mention it. What we typically do, we tell our client how to do it, but if we see that they're not able to do it or it's just too much of a burden, we will do it with them. I should mention that this form is also available online. So you can Google Wills Notice Vital Statistics Agency, make sure it's the secure form from the British Columbia website. It will have, the little lock. And you can pay with a Visa debit or credit card, the $17 to Vital Statistics or the Ministry of Finance. By the way, that form, it's a two-pager. On one side of the form, it says you can pay the $17 to the Minister of Finance, and on the other side, say to Vital Statistics. It doesn't matter. I prefer to do it online because it's filed immediately. You don't have to worry about postal strikes, whether it gets lost. You file it, you have the receipt, and then you're done. So with our client, yeah, we try to do it with them when we have time, and then they can pay using their credit card, and if it's a hardship, we might pay for them. Any other question?
Yeah, that's one other one. I think I've heard this one come up before, is the idea that, what if someone doesn't know if there's a will filed? They have the will, the document. It looks like it's the legitimate document. It was signed by the older adult, but not by a lawyer. Is there any way to look it up if the document, especially if the document was made years ago, like 20 years ago?
Well, it's only you should only check once the person has passed. So when you go to the probate registry, they will require a will's notice search to be performed. And if it's empty, it doesn't mean that there's no will, but it shows that whoever wants to be the administrator of the estate, because they can prove that they have a will. So if there's no will, by default, you will assume that there's, if no will's notice, again, you don't file the will, you file the notice that there's a will that has been executed. So if you want to apply to become an administrator of the estate, you will do a will's notice search. And if something comes up, it's like, oh, will was done 20 years ago, then you should do everything you can to try to find that will before saying that there's no will, because it's been filed, right? You cannot really check when the person is still alive other than by asking or looking around if you have the authority to do so. In some instances, you can try to see which law office may have a copy. So as a nonprofit, we don't keep original wills, but private firms typically keep the original or certified copy of the will. We typically keep just a copy online, like on our OneDrive, basically, and on a digital copy of the will that we sign for the client. It has happened that the will was lost, and we will release the scanned copy to whoever was named as executor. But other law offices may still have the original. Actually, there's a duty by law firms to keep wills for 100 years. So hopefully that law firm would still have it or have a certified copy of it. All the notes. Okay. Okay, what happens, we're going over time here, if you become incapable without an advanced care plan? So when it comes to healthcare, they will look for a temporary substitute decision maker, and that's set by the law. So they will look at any representative or past representative, like they will look at the spouse, the children. There's an order set. For financial matters, though, as I mentioned, that's when you need to have a committeeship application. There might be a pension trustee. It used to be the Bloom Group oftentimes, but I understand they don't take more cases because they are swamped. There are a few others, like Coast, for people with mental health issues, and the public guardian trustee could make application to the court as well. And on that note, when there's no one, even if the public guardian trustee gets involved, they may decide to to have a family member appointed. So what the public guardian trustee does is always look at, is there anyone else who could do that, who could be a substitute decision maker, so we don't have to be involved? And when I say we, it's them, have nothing to do with their office. So again, just a reminder to think about, who does what. I understand many of you actually executors, representatives, and attorneys. Where are the legal documents kept? And if you hire a lawyer for yourself, or you want to help a loved one, just make sure they specialize in dealing with these requests. You don't have to use the same lawyer who helped you with your divorce or your motor vehicle issue to do your will. It's important to pick someone who does that on a routine basis and ask for the cost upfront. Some resources, the slides will be shared with you, so I am over time, so just very quickly, there's some information online from the government of BC. People's Law School has a lot of information that's done by lawyers, like it's written by lawyers, so it's reliable. NIDIS is great. They have a centralized registry where you can keep scans of those documents for a fee. Plan Institute of BC as well. It's been a while since I talked to them. But again, so that's the link to our publication, and I'm happy to take any questions you may have, assuming I can answer them.
So there is one question here in the chat. I didn't bring it up earlier just because it was relating to Section 9 and we were sort of past that area. But the idea is once an adult dies and there's a Section 9 representation agreement, of course, it doesn't have any more legal effect. What are the legal mechanisms by which the former Section 9 representative or a close family member, how can they obtain the deceased medical and long-term records? And sort of the second part of this, how do health authorities distinguish between that expired representative authority and valid post-death access rights under FIPA or state law? None of which I understand, since I'm not the lawyer.
Okay, so FIPA would be for health authorities, and PIPA would be for could be for private authorities. So maybe what I'll do is I'll just share my entire screen after I show you the form that is typically used for FOI requests, because that's set there. So I'll give you an example. If there's any health authority in particular that the person wants to mention, again, that one, like Interior Health, or where is the request?
There's two parts. There's so how can somebody get the person's medical and long-term records, and then the other is that. So the person who, Caroline, if I could ask you, which region are you in, Carolyn?
Well, I'm in the Northern Health region, but it really goes to the heart of, okay, the person dies, you weren't able to get the care records or medical information throughout the process of the dying days, but now your Section 9 representation is extinguished. FIPA won't likely recognize that, but are there any other estate law avenues that a person can go through to get that vital medical information that may be needed?
Yeah, it would be the executor typically, but if there's no executor, usually it's on the form. So I'll give you an example. It's a Northern Health request for health records. You have to file them all the time. So if you see here, they are incapable to go to the representative, right? And this is usually someone for himself. So first of all, number one in line, as we say, it's a representative of the power of attorney, for the one with the power of attorney who has authority. The minute they die, for healthcare decisions, it's no longer the representative. The executor takes over. When there's no executor, is the administrator of the estate who has the same powers as an executor. And that's why you see number one in line here would be the executor, or the administrator of the estate. And then they look at the last committee of the person, and If there's no executor or administrator, no committee of the person, then you look at the nearest relative. So it's the spouse, the adult child, parent, sibling, others. So it's the same order as who can be appointed as a substitute decision maker or beneficiary when there's nothing in place. So you follow the same list.
Okay, thank you.
Yeah, and typically they would ask for a death certificate and then prove that you are who you say you are here. So if
Sure.
it's a spouse, marriage certificate or detailed birth certificate. I've done that for clients. However, when they release strikers, so I'm going into like the weeds here, like they're going to look at whether the patient would have wanted to have this information released to you. So otherwise, they might redact or refuse to release certain information. So yeah, that can be the subject of a order consultation. We've seen that where, for example, someone has specialized care or mental health issues, and it appeared that the person requested the request was a parent or a spouse, but they were fighting the patient on some of the decisions they made, and therefore the healthcare providers found that since they disagreed on the type of or the course of treatment, then likely the patient would not have wanted those records to be released to them. I'm simplifying it, but just to give you a broad idea of what could happen.
Oh, I understand. I mean, I know that the the Office of the Information and Privacy Commissioner adjudicated this very issue, and the information stayed sealed with the death of the loved one, so the family could not access the records from that venue. But anyways, yeah, thank you.
Welcome. I hope it helps. Anything else? I can look at the chat itself.
And I just added a note in the chat as well that in the next day or next week, I will forward a copy of the slide information to Lisa, and then she can distribute to you if you like to. So in addition to the recording you're making, sometimes it's easier to look at print. So there you go. Any other questions?
Well, thank you so much for attending. I understand that many of you
Maybe take one more question.
Yes, I will take that question. Absolutely. In fact, it would be great, to have that information in the normally it is actually specified in our presentation agreement. We have our own form, and we list that and what are the things that the person can request. So I understand that this person can make decision about my personal care, healthcare, including where should I live, who should I live with, like who can be a visitor, type of treatment I receive, my food, dietary restrictions, spiritual choices, and they can access our records. How prevalent is elder abuse in BC long-term care homes? That's a great question. We don't really know, because the truth is, when we look at our sales statistics, so we receive about 8,000 calls per year now. It used to be less, but anyway, only a small percentage of the calls come from long-term care homes. But the thing is, who can access our services too, right? So I'm not sure that the people who are being abused always have the ability to reach out for help. So oftentimes when we hear about elder abuse in long-term care homes, it's from a loved one. A spouse will call and say, my husband has been in long-term care. In 3 months they've lost their physical mobility, so much has changed. What can I do? They are being neglected, and we have a conversation. Yes, Lisa?
I'd just like to ask a quick question. I'm sorry, we are over time, so I acknowledge that there are people that have to carry on with their evenings. But I'm curious at this juncture because, it is really up to the spouse or often the children of those in long-term care to advocate and speak out on behalf of them. Lately, our organization has received inquiries about video surveillance and care homes deciding either to put or not to put surveillance in rooms. And it's interesting, it's both either choosing to tell the families, no, we can't, or saying to the families, this is what we're going to do. And even, pulling police into the matter. So just curious, some people take this as a form of abuse because there's no privacy and there's lack of dignity and then other family members are saying, oh, we actually want surveillance in the room because we know there's abuse going on that's coming through the team channels. But so these I was going to say these kinds of conversations and concerns, if they reach you, aren't counted as abuse statistics that you're receiving because they're not directly from the adult?
No, we count them as stats. Yeah, we would just know whether it was reported by
Oh,
the older adult themselves or a third party.
and do
And
you
there's a
have
lot of, sorry.
and do you have information or resources on the legalities of use of surveillance in residential care?
That's a much bigger conversation. Typically, though, facilities do not want to have video surveillance because of the privacy of their staff. So we hear more about family members who want video surveillance and the facility resisting it than the other way around. But I won't get into personal opinion here, but if it comes to that, yeah, like that's a huge well, the rights of the resident, like
Risk.
which really is the resident living alone in the room? Is it a room shared with someone else? Because if shared with someone else, then what you have to think about the other person who's there, and you have to think about the dignity of the resident themselves. Like most of the time, like you wouldn't want to have a camera in your own bedroom, would you? Like,
Yeah.
so I haven't seen cases where facilities wanted to have video surveillance in the room of the resident. Um, but if that's an issue, I'd like to hear about it,
Hey, thank you.
of course.
Does anybody else have any questions? You're a wealth of information. You've got a ton of resources, and I hope everybody is now anxious to see your website and poke around and see the tools that you have so generously crafted for us there. And of course, your sale line and other ways to reach you. So thank you very much, Marie Noel and Linda, for being here this evening, and everybody else. We will distribute the resources. It'll be on our website. ILTCCABC greatly appreciates you being with us this evening.
Yeah, thank you all for attending, and I'm sure many of you are also caregivers who are exhausting on many duties. So thank you for making the time for this session as well. Have a good night.
Thank you.